Today we'll be speaking about quite an important issue, I guess, which many of you meet in your real life. And so I guess we need to start now. And I give the floor to Christophe to start with the presentation.
Good morning, everybody. So my name is Christophe, as mentioned by Maxim, and I'm one of the two partners leading our employment practice in CMS Russia. So while the need to protect sensitive information essential to business has always been understood by businesses, in the past, within the frame of employees-employers relationship, the latter often rely on an implied ethical duty of confidentiality followed by their employees, while actually this duty has never been or was never properly formulated. But over the time, it appears that employers have and are facing new circumstances, among which I will mention a few, knowing that this list is not exhaustive. So first of all, we have the increased mobility of the workforce, because from now we can see that jumping during a career life from one job to the other one is a real trend. We have as well the development of IT technology, allowing paperless office and electronic storage filing system, which provide access to a greater number of people to sometimes very important information. We have as well, and sometimes it's forgotten, but this is very important, the fact that employees are, during their free time, are very active on the social media platform, and sometimes it's very easy to be less careful than when they are at the office. We have as well the use of laptop outside of the premises of the employers, and I'm sure you have all been, when either being in a plane or in a train, sitting next to someone working with his laptop, and we are all curious and having a look at what was going on, and which sometimes can be very damaging if some confidential information are shared. And the last factor I would mention is the use of mobile phone in public place, where sometimes you can hear some confidential information. And hence, we all understand that the leakage of information can be very detrimental to the reputation and or financial standing of a company. Maybe some of you remember the scandal in 2006 about Coca-Cola, where actually the receipt of Coca-Cola was proposed to be sold by some ex-employees, and which could have been very damaging for the company. So this is why the businesses are taking and employers are taking all possible measures to protect their confidential information, and it can be through encrypting data, through use of specific IT systems, and as well as offering adequate and proper training. And besides the change of circumstances, it appears as well that having a single provision on confidentiality, as it used to be, was not enough to encompass all possible circumstances. And such a simple and single provision didn't have a deterrent psychological effect on the employees. And this is the reason why entering into NDA, non-disclosure agreement, and we will talk later on about the form this NDA can take, has been increasingly growing in number, while at the same time, this can lead to some negative effect from the employee side, such as for the new joiner, they can feel from the very start a kind of mistrust when they are required to sign such a document or to comply with such a requirement. From the top tier candidate, it can be a problem because they may feel that they will have or they will be limited in the future to be able to talk about their job experience. And for current employees, sometimes they feel a lack of trust or losing trust from their employees when they are required to sign such a document. Nevertheless, according to a very recent survey in the United States, it appeared that more than 1/3 of the workforce in the United States is subject to NDA, forbidding them to talk from trade secret up to assault or sexual harassment. In Russia, coming back to what the situation in Russia, it has been now very popular and common in practice to supplement employment agreement with extensive provision on confidentiality. And we have seen as well the development of special legislation in relation to commercial secrets. And this is this legal regime that we are going to present you with Maxim during this webinar, as well as the court practice related to this issue, and knowing, as mentioned by Maxim, that if you have any question, you can insert them in the chat, and at the end of this webinar, we will answer them. But let's start with the first item on our agenda, which is the legal regime of NDA in Russia. So first of all, I'd like to mention that as such, NDA, there is no specific regulation on NDA under the law in Russia. And therefore, when it comes to concluding such an agreement between, for example, participants of a company, they will rely, and such an agreement shall be governed by the corporate law. Between business partners, they will refer to the provision of the civil code, and within the frame of employees-employers relationship, such a provision agreement will be subject to the provision of the labor code of the Russian Federation. And this has been reminded, if I can say so, by the court decision which is on the screen, according to which NDA between employer and employee is not a civil law document, and it shall be regulated by the provision of the labor code. And according to Article 57 of the Russian Labor Code, an employment contract may provide for a condition of non-disclosure of legally protected secrets. Here we are talking about state secret, official secret, or commercial secret. But this condition, this specific condition, should not worsen the position of the employee as compared to the provision of the labor legislation. But however, and it must be noted that under the Russian law, and regardless the parties to an NDA, such an agreement shall be fully operational if all legal formalities are met. And to the extent, I would like as well to remind that according to Federal Law 149 on information technology, and information protection, condition for attributing information to information constituting secret, the mandatory confidentiality of such information, as well as liabilities for its disclosure, are and must be established by federal laws, and in relation to commercial information, Federal Law number 98 on commercial secret was passed in July 29, 2004, which set actually the regime of confidentiality of such commercial information and commercial secret. And according to this, to Article 3 of this law, commercial secret may include any information, and we will have a more specific example later on, any information that has actually or an actual or a potential commercial value due to the fact that it is unknown to third parties, or due to the fact that third parties do not have free access on a legal basis. And according to Article 10 and 11 of this Federal Law number 98, in order to establish a commercial secret regime, it is necessary to fulfill some requirement, and the following requirement. First of all, to determine the list of information, and we will see later on how to do it, to establish the order of access and treatment of to this information, to keep a record of the person who receive access to the commercial secrets, define in the employment agreement the conditions governing the use of commercial secret, and to put on material carriers of such information the mark commercial secrets. So as we see, there are quite very strict requirements in establishing to establish this commercial secret regime. And only after all, according to the law, only after all these measures are taken, can it be possible to sanction an employee for failure to comply with the commercial secret regime. And what are, according to the law and to the Russian Labor Code, the sanctions which may be imposed upon the employee? They are twofold. First of all, firing, and this is provided by Article 81 of the Labor Code, which states that an employment contract may be terminated by the employer in case of disclosure of legally protected secrets, including commercial secret, which has become known to the employee in connection with the performance of his work duties. And the second sanction which may be imposed, and it is possible that both to impose both, is the loss recovery, and this is provided by Article 243 of the Russian Labor Code, which states that if an employee discloses information that constitutes a legally protected secret, including commercial information, he shall bear material responsibility in the full amount of the damage caused. So based on what I've said, it must be noted that it is impossible to sanction and to provide in an employment agreement as a sanction in case of violation of the confidentiality regime a penalty clause. And if such, first of all, it will be void. And in addition to that, the employer may be subject to administrative liability. So coming to the end of this first part of our webinar, I would like to conclude that according to the law, bringing an employee to any liability for disclosing commercial secret is subject to the compliance by the employer with the requirements we mentioned. But the question which we may ask now, and to which my colleague Maxim will answer, is does the failure from the employer side to comply with some or all the requirements will automatically entail the rejection by the court of the sanction which may have been imposed by the employer over the employee? And to answer this question, I give now the floor to Maxim. Thank you.
Thank you, everyone. Thank you, Christophe. Let's move on. Now we're moving to the little bit to the court practice. Christophe has already mentioned, said a few words about the commercial secrets regime, which is quite formalistic, as we literally read the long commercial secrets. Although I should say also that Article 10 of the law on commercial secrets, while listing all these formalistic measures, also contains a provision which says that the commercial secrets regime is still considered to be established also when the employer took the appropriate measures to exclude the access of third parties to the relevant information. And there is also a decision of the Constitutional Court of Russia which spoke a few words about that, but we still don't see a lot of practice confirming that the commercial secrets is considered to be established based on this provision. But anyway, so still, the main question which I raised to myself when in our practice and when also preparing for this webinar, is still a commercial secrets regime necessary to apply the liability onto the employee, the disciplinary liability or the material liability of the losses? Although I should say that the second one, I mean, the material liability is it's almost never met in practice. So the main liability which the employers try to impose onto the employee is a disciplinary liability. So is the commercial secrets necessary, or can we rely on confidentiality provisions in the employment contract or in the separate NDA? So we just say that information is confidential, signed an agreement between two parties, or again, it could be a part of the employment contract or a separate NDA, without establishing all those very formalistic measures which are listed by the law on commercial secrets. And the practice is as follows. You can see a number of just examples of court cases, but I should say that in the vast majority of court rulings, the courts, while resolving considering the relevant cases, they still apply the term commercial secrets, and they still pay attention to the establishment of commercial secrets in the company. Although, and we will speak about it a little bit later, it's interesting that the courts they don't really analyze how the commercial secrets was implemented for instance, they do not ever check whether the documents are labeled, for instance, in the company. What they really pay attention to is there is a commercial secrets policy in the company. This is the most often met point, and the courts pay attention to it. So the adoption of a commercial secrets policy, and there is some provision in the employment contract or an addendum to it. In some cases, we also met separate NDAs concluded by the parties, in which there is a reference to this policy. As you see in all these cases, cases number 1, case number 3 on the slides, there is a commercial secrets regime. In case number 2, there was no commercial secrets mentioned. But still, we cannot say that this case is a good example because it's still not resolved. The cassation court cancelled the decisions of the lower courts, which confirmed the dismissal. But it's interesting that in that case, the absence of the commercial secrets regime was not considered by the court as an issue. So there were other grounds for the court to cancel the decisions. Another 2 examples. The first case, again, there was no commercial secrets regime established by the employer, but it was confidentiality policy adopted by the employer. So this case is a good example that still it might sometimes be possible, if there is no commercial secret regime implemented in the company, to apply the measures against the employee. Although in this case, there is no dismissal. The sanction was a reprimand, so quite a softer sanction against the employee. So maybe that is why the commercial secrets issue was not analyzed in too much detail by the court. And then the last example, there was an NDA, a separate NDA signed between the parties, but there was also a commercial secrets policy adopted by the employer. There is also a ruling of the Constitutional Court of Russia. I'm sorry, a ruling by which the court has, there was a claim from a person who tried to challenge the provision in the law on information technologies and protections of information. And this claim was denied by the court. But as always with the Constitutional Court of Russia, while they denying the claim, they still try to analyze the issue in many details. So they spoke about many issues in that decision. First of all, they mentioned this provision in the law on commercial secrets, by which the commercial secret regime is still deemed to be established if the company has implemented reasonably sufficient measures to exclude illegal access of third parties, which makes us think that if we take reasonable measures in the company, we can still try to consider the commercial regime as being implemented without implementing all those formalistic steps, like, for instance, labeling the documents as commercial secrets or as confidential. The court has also paid attention to the fact that the company has taken necessary measures to restrict access to its confidential information, including by way of directly informing the employee about the prohibition to disclose the information to third parties. So, summarizing the current practice and these clarifications of the Constitutional Court of Russia, is this commercial secret regime is necessary, or can we just say that the information is confidential and conclude an NDA, for instance? Well, the first conclusion is that the courts still use the term commercial secrets more often than just confidential information. So, based on that, it would be safer for the employer to implement a commercial secrets regime, and especially when we are talking about the cases of immediate dismissal of employees. So then, when the employer takes the most severe sanction to the employee for disclosure of commercial secrets, and how to implement this commercial secret regime. As Christophe has already said, the most safeguard approach would be to literally implement all the protections measures listed in Article 10 of the law on commercial secrets. So everything which is listed there, so defining the list of persons who have access, defining the list of information constituting commercial secrets, including the relevant obligations into the contracts with the employees, and labeling the documents as well. But as I already mentioned, in the court practice, the courts, although they use the term commercial secrets in relevant cases when there are disputes with the employees, they still do not analyze, the applications of all measures according to Article 10 of the law on commercial secrets. What they usually pay attention to is the presence of certain policy in the company, which defines the list of information which constitutes commercial secrets, establishes the relevant obligations, and also there is separately, there is also a provision in the employment contract with the employee or a separate NDA concluded with the employee, and these two documents are connected to each other. Summarizing this, a conclusion of NDA with the employee or including the provisions into employment contract with the employee is a good point, but we advise you to use the term commercial secrets, as the courts still like it more than just confidential information. And we advise separately to adopt an internal policy and commercial secrets policy in the company. Also, what is important when we're talking about commercial secrets. So as I mentioned, the commercial secrets regime and its establishment it's advisable and very important. But sometimes the employers, when they define the list of information which constitutes commercial secret, we try to include everything in it, which is actually a good idea. You need to make the list as broad as possible in order to protect yourself. But it should be noted that some of the information cannot be considered commercial secrets, no matter if it is included in the list by the employer. There is a list of information which cannot be considered commercial secrets under the law. It is mentioned in the law on commercial secrets. And on the next slide, there is also a ruling of the Russian government, 1991, on the list of information which may not constitute commercial secrets. So this information is excluded. It's not commercial secret, no matter if it is included in the list or not. Sometimes the courts also consider practical nuances of the case. As Christophe has said, the criteria for the information to be considered commercial secret is that it shall have actual or potential commercial value due to being unknown to third parties. And third parties shall not have free access to it on a legitimate basis. And sometimes it's due to the nature of information that it is not commercial secrets because it's known to third parties. Just an example, there is a ruling, a decision of the case, decision of the court, where the court has said that information disclosed by the employee about the availability of the goods and their prices is not secret by its nature because it is present in the employer's catalogs, booklets, and price lists which are available to third parties. So here's a good example that sometimes, even if you define it as commercial secret, but the employer still itself does not treat it as commercial secret in its activity, then you cannot, apply a sanction on the employee for its breach, for its disclosure. And another example of of the court case is then, for instance, there is information of the number and composition of the employees in the company, which due to the law cannot be considered as commercial secrets. However, the court has mentioned that information of the recruitment process of the company. So there is some little bit difference in between just an information of the number and composition of the employees and information of the recruitment process. And information of the recruitment process, it's how the company is recruiting people, what are the criteria for recruitment, what are the current open positions in the company. This information may be considered commercial secrets if it is considered as such by the employer. And that is why for its disclosure, the employee can be disciplined, can be sanctioned. What is also important is that the employer must prove the fact of disclosure of information and the employee's guilt in it. As we all know, due to clarification of the Supreme Court of Russia, it is the burden of the employer to prove the fact of breach, to prove the legal grounds of dismissal, if there is a dismissal of the employee. That is why the collection of evidence is quite important in this case. When we speak about the disclosure of commercial secrets, of confidential information, we understand that in the current, in the modern world, most often the disclosure takes place using electronic means of transfer of information. We have met a lot of cases where the employees disclosed the information through by sending the employer's confidential data to their private mailboxes. And actually, the latest practice on this is quite successful for the employers. So we have even met one case when the employee sent information to his private email address in order to work with it for the employer, not for in its own interests. But it was still a breach of the confidentiality of information, because the private mailbox was, if I'm not mistaken, it was mail.ru. It's not controlled by the employer, it's controlled by third parties. So there's no ability of the employer to protect information in that case. And that is why it was considered as a breach by the employee of confidentiality obligations, although it was not a case of dismissal. It was a kind of a warning or reprimand, if I'm not mistaken, which the employer tried to impose on the employee. So proving the fact of disclosure is important. And as soon as I mentioned, the information is very often leaked through the technical means, through the internet, and that's why the employer should have sufficient technical equipment, software, hardware, in order to detect relevant cases. So if there is an internal investigation, which is advisable to undertake if there is a case of a breach, so the employer should just start an official investigation and somehow protocol the results of this investigation, because it would be good evidence then to be presented to the court. What is also often met in the court cases is that the courts sometimes pay attention, not very often, but sometimes they pay attention to the severity of a breach and the possibility to apply a less strict sanction to the employee. So not an immediate dismissal, but a warning or a reprimand. Because the employer has a choice. It can apply either warning or reprimand or an immediate dismissal onto the employee for a breach of confidentiality. And sometimes courts pay attention to the real facts of the case and the ability of the severity of the breach and the ability of the employer to apply less strict sanction among those three. The court also pay attention to the fact that the employee has not had any records of any previous disciplinary offenses. And there is an example of two court cases in which all those facts have been analyzed. So now we are moving to the next slide and how to structure an NDA. So when we are talking about the structure of NDA, we also mean structuring the confidentiality provisions in the employment contract, because as we earlier said, most often the employers do not conclude separate NDAs with their employees, so they rather include the relevant provisions in the contracts with the employees. And I again give the floor to Christophe to speak on those points.
Thank you, Maxim. So now let's see in concrete how in Russia these confidentiality provisions are set within the frame of employers-employees relationship. So first, we have a standalone agreement, NDA agreement, which, and I'm sure Maxim will agree with me, at least in our practice, we have not seen a lot. I will just mention a few cases where indeed we assist our client in concluding such a standalone agreement. But if we compare the situation in Russia to the situation in the States, for example, this standalone agreement on NDA is not yet very well spread in Russia. But if you want to recourse to such a document, what I'd like to notice is that generally standalone agreement NDA shall provide for, of course, the party concerned, the list of information constituting commercial secrets, and I will give you some example. Of course, the prohibition, restriction, and obligation for and to the employee in concerning the use of such information can be, for example, the prohibition to print outs of such or some information. The information which are not subject to and are not covered by the confidentiality treatment, and of course the liabilities which may be imposed on the employee should he violate the provision set in this NDA. But once again, in Russia, we have not seen a lot of such an agreement, generally speaking. Concretely speaking, what information can be considered as confidential information or commercial secrets? I will just read a few examples. We have, for example, the customer and client lists, including contact information and preferences, fee, cost, and pricing structures, business and operation plans and methods, trade secrets, quite obvious, innovation, ranging from ideas to invention and from research to a new development, distribution and sales methods, systems and strategies, marketing and advertising information and strategies, manufacturing know-how, distributor, vendor, supplier, and contractor information, computer software, application and programs, and confidentiality information obtained from third parties under an expectation of privacy. Of course, this list is not limitative, and it will depend on your specific activities, and this is why it is very important, while you set the list of information which you consider as being commercial secret, to think about it very carefully and to be specific and to be clear. And one interesting example we have had from a client, when Maxim mentioned that actually some products which are on the stocks cannot be considered as a commercial secret. We had the case from one of our clients in the luxury industry, having very specific and exclusive items. And it is considered that, and it is for this client crucial that such information and on such item being in the stock be not disclosed to their customers. And once it happened, and we had to fire the employee or to terminate the employee went to court, and actually considering the specifics of the activity of this employer, the employer won actually, and the termination was validated in these specific cases. But as I said, NDA is not very used actually in generally speaking in the frame of employees relationship, and most of the time actually these provisions are construed in the employment agreement itself or as an annex, in which actually we provide for the employees compliance with commercial secret regime and the employees familiarization with the list of information constituting commercial secret. But as mentioned earlier by Maxim, such a provision itself is not enough if you want to, or at least should be complemented if you want to be successful in sanctioning your employees should there be any disclosure, is to supplement this the specific provision you may have in the employment agreement or in an annex to the employment agreement by a secret regime policy or secret regime regulation, which shall contain the nature of the commercial secret, the access procedure to such information, the obligation of the employees toward its use, and of course the liability. But be very specific and clear when defining the information that you consider as a commercial secret, and making sure that actually these, according to the legislation we mentioned, making sure that these information are indeed may indeed be covered by the law on commercial secrets. Another interesting fact is that in your NDA, to speak globally, be a standalone agreement or specific provision in the employment agreement, an interesting fact about sanction is that you may still impose sanction as provided by the labor code, even if the agreement, employment agreement is terminated. Of course, should this provision be inserted in the employment agreement. In other words, the sanction will survive in case of a disclosure of a commercial secret, the termination of the employment agreement. But of course, if the employee has left the company, you will not be able to terminate the relationship. It has obviously already been terminated, but therefore you will be able to claim for compensation of the loss which you may have incurred due to the leakage of commercial secret, should you be able to prove the actual losses that you have supported and which are borne. And coming close to the time which is granted to us, if we want to have time to answer your question, I would like the last slide just to provide you a few practical tips. And Maxim touched upon when he was talking about the court cases, is not only to have a specific provision, detailed provision on commercial secret, on confidentiality issues, the regulation on commercial secret regime, and but as well to have a policy on the use and detailing the use of corporate email systems and IT. And this can cover as well professional phone calls, for example, so that the employee knows exactly how he can use and what he should do and not should be doing in using internet corporate email or corporate email. And Maxim mentioned it, but I would like once again to remind you that in case you have a breach of confidentiality, make sure that this is duly documented by the employer, by yourself, and if you may have witnesses, and witness statement, it strengthens your position. Another thing, make sure that you have developed IT systems which are entitled you, first of all, to fight and to stop any potential leakage of commercial secrets, and as well to be able to, IT systems which are able to explain or to demonstrate and show what kind of leakage took place, and because sometimes the courts required some proof and such a document. And last point I'd like to mention, and we have seen the case, sometimes your commercial partners and sometimes our client ask us, besides the confidentiality provision we may have in our employment agreement and besides the one which are set by the various internal policies that we have in our office, sometimes, as I said, our client ask us to some specific, very specific confidentiality measures. Chinese wall, for example, it may happen that, for example, we with Maxim in our employment practice, we are not entitled to talk to our colleagues in IP department while they are working for the same client to disclose what we are doing. And this may happen as well, especially when, for example, sometimes in a vendor-seller situation, when we are representing both companies, but still our client asks us not that one team doesn't speak to another team and things like that. In this case, make sure that your the employment agreement mirror the requirement on these issues that you may receive from your partner. And in our case, for example, we just had an annex to our employment agreement by which we shall agree to comply with this specific requirement of our client. So it often, to be honest with you, we have often seen the case where clients receive from their business partner such a requirement, and actually it is not properly formulated and documented in the internal relationship of employer-employees towards these business partners. So it may be a challenge later on. So coming close to the conclusion of this webinar. So just would like to remind you that indeed in the Russian legislation we have a specific federal law on commercial secret, which set quite stringent requirements to be followed to be able to bring an employee into liability should he fails to comply with this requirement. Maxim explained us that the courts sometimes may be less strict, but still, and they will look at the whole surrounding of the situation, but still it is highly advisable to have a specific regime. But one, and this is based on our practice, there is one thing which should do is remind on a regular basis your employees on these on all the issues which are related to the treatment of information, how to be careful, not only within the premises, not only with colleagues, but as well outside. And this is done by regular training, and we do it internally, and it can be a regular training on, even if it looks maybe obvious, but on how to work outside with laptop, what kind of precautions you should be taken. It can be as well securing your laptop when, for example, you are during your holidays, you are in your bedroom. Make sure that your laptop is properly secured by a metallic wire, so that no one can or put it in a safe or thing like that. So very practical issues that we remind, and we strongly advise you to organize regular training, and especially with the joiners on this specific issue. So we thank you very much for your attendance and for your participation. And now I've seen that we have a few questions, so that we'll answer. Maxim, would you like to take the first one from Natalia Kovalyeva?
Yes, sure. Thank you, Christophe. So the first question, I'll read it just for everyone to know what is the question. Diro, do you have the court practice when breaching NDA leads to real damages to the company? If so, could you please name the cases? Thanks. So first of all, in our practice, what the employers try to impose to the employees is disciplinary sanction. We did not have cases that the employers tried to claim damages. As we know, the Russian, but there is a possibility for that. So the Russian labor code, as I mentioned during our presentation, there could be a disciplinary sanction applicable to the employee, which is a dismissal, reprimand, or a warning. And there is also the right to claim material losses. No consequential damages, because this is not a civil law liability. It's still a material liability under the labor code. And in case the employee, there was, for instance, there was a commercial secrets regime duly implemented by the company, and sometimes the employers even try to include into the employment contract that the employee's obligations they survive the termination of employment and last for other periods after the termination of employment. This applies to confidentiality obligations of the employees, which is quite natural, of course, because even though the employee leaves the company, it's still quite important not to make this information open to third parties and to open public. That is why after the employee has left the company, the disciplinary sanction doesn't make any sense, because the person is not already the employee. But as we mentioned in our presentation, you can still try to claim the losses. In order to claim the losses, the company has to prove them. To prove the losses, you have to collect the evidence in order to justify the amount of the losses and the consequential link between the breach and the existence of the losses, and of course you will have to prove the breach itself, which is quite difficult because each case of a breach of confidential information, usually it's a headache to prove that there was a real leakage. Then the person is within the company. Sometimes you can prove it because you can detect the actions of the employee, like for instance sending the information to private emails from the company corporate system could be detected. But then the person is outside the company, it's quite difficult. You have no technical means to prove that. Maybe some witnesses can prove, but the cases of that kind are quite rare. So that is, and also important thing, how to pursue the employee. Another legal remedy available to the employer. If they are talking about the commercial secrets regime, there is even a criminal liability for the disclosure of commercial secrets, and the employer may try to apply it to police if it has some evidence. I don't know which, but sometimes you might steal certain evidence after the employee has left the company. Or even if the employee is within the company, you can initiate the criminal case against the employee, although it happens quite rare, of course. So there is such a remedy. It's quite threatening, could be quite threatening to the person, and so bear this in mind. So you may, if there is a commercial secret regime, because the criminal code deals exactly with the term commercial secrets. So not just confidential information. I guess we try to answer this question and just move over to the second question.
But actually, Maxim, you have, unless a second question from Sergei Tsibninov. Sorry if I mispronounce your family name. I guess you covered in your answer, you covered, and you may go through, but you covered what Sergei was asking.
Anyway, just read the question, and if an employee leaves the company and then uses the company's commercial secrets, assuming that the company has a proper commercial secrets regime, which is good, to gain an edge for a competitor, what course of action would you recommend? As I understand, it doesn't seem to be realistic to sue such employee for damages. Well, if you have evidence, as I said, the most difficult part of this process is to collect the proper evidence over the breach, the fact of breach, and you can prove, if you can prove the breach, you can prove the damages, you can prove the link between the occurrence of the breach and the occurrence of damages by the company. They could be realistic. As I said, you cannot claim consequential damages from the employee, like loss of profit, for instance, because this is not a civil law claim. It's still subject to the labor code, which speaks only about direct material losses caused to the employer. So that's it. Other course of action, as we mentioned as well, the criminal, try to think about initiating the criminal case against the relevant person. And also keep in mind that when you include the relevant confidentiality undertakings into the employment contract or into a separate NDA, try to, well, it's advisable to include that the relevant obligations survive determination, because it's important for the employer.
Thank you, Maxim. And maybe that will be our last question, considering the time frame that we have. Last question is what is your view on using NDAs for specific projects like restructuring or M&A deals, in addition to the standard contractual NDA provision in the employment contract? Yes, thank you and for this question. And this is what I mentioned and what was mentioned on the point 4 on the slides that we have in the screen. If you have a specific requirement or request from the client you are serving on confidentiality issues, yes, indeed, it is very important that these specific requirements be added, as I said, in an annex to the employment agreement, or be added to the general provision on confidentiality issues, to make sure, first of all, towards your partner, that you have indeed fulfilled their requirement and their request, and as well in case of violation by the employee of any confidentiality issues connected to this specific project, that you may be able to sanction, as mentioned, as Maxim said, depending on the gravity, but it can be progressive, but you may sanction. But even towards, from a pure responsibility as a company towards, and this is what we do internally towards our clients, for example, when we have specific requirement, we are making sure that at least the people involved on this very specific and very large project shall comply, first of all, are aware of the client's requirements, and then shall comply with them. Maxim, do you want to add something on this?
Well, in our practice, when we see commercial contracts, there is indeed a lot of cases then the partners agree between themselves that each partner, or the party which receives the confidential information from the other side in a commercial contract, takes an obligation to impose a similar confidentiality undertakings onto its employees. Sometimes when we read such contracts, it means sometimes that literally all the same provisions which are contained in a commercial contract should be just copied in the contract with the employee. That's why our advice when you conclude the commercial contracts would be just to think about the wording of such a provision, such an obligations when we speak about the employees. Maybe not to say identical provisions to be concluded with the employees, but something like the employees shall be obliged to maintain confidentiality in a way which ensures the no disclosure of information to third parties, and provides the same effect as contained in this contract. So not just copying the same provisions, because of course you probably already entered into the employment contract with your employees, and there are some obligations in it concerning confidentiality, but they're not literally the same as in this contract. So not just to copy paste the contract and conclude a separate NDA. Maybe sometimes we need to a little bit rephrase the wording in a commercial contract. But it's also okay that sometimes it's a strict obligations to conclude a separate NDA with the employees in relation to a specific commercial project. So in that case, you cannot avoid this, and you need to enter into such NDAs. Sometimes, we met also the cases then the partner required the other side to present the copies of already signed NDAs with its employees. In that case, think about the disclosure of personal data of your employees. So you might probably also need to collect the personal data consents from your employees in order to disclose their data to the third side, to the commercial partner. So that is more or less the current practice on this issue.
Thank you, Maxime. So, and actually there was more or less the same question from another attendee, so which I'm not going to read because it repeats what we have just said. So coming to the end, it's 11:57. To the end of this webinar, first of all, Maxime and I would like to thank all the attendees for your presence. And if you have any questions, so you will, yes, you will have our contact detail, because this webinar has been recorded, and then you will receive our presentation with our contact detail to your email address. So if you have any question, we will be pleased to answer. We wish you a nice, not end of the day, but nice day. And unfortunately, considering the time being, be safe and sound, and take care of yourself. Thank you very much. Bye-bye.